Good morning. It is April the 9th, 2013, approximately 10 a.m. I'll call the meeting of the Department of Commerce and Insurance Board of Funeral Directors and Embalmers to order. And we'll ask Ms. Lisa Mosby to call the roll, please.
Wayne Hinkle.
Here.
Tony Highsmith.
Here.
David Neal.
Here.
W.T. Patterson. Jane Gray Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor. Mr. President, everybody's accounted for except for W.T. Patterson and Miss Anita Taylor.
We have a quorum present. We will continue with the business of this board. You have been presented a copy of the agenda for this meeting, and I'll ask you to review that. We'll entertain a motion for its acceptance.
Make a motion for the acceptance.
Mr. Starkey has made the motion to approve the agenda as presented, seconded by Mr. Neal. All in favor, say aye.
Aye.
Any opposed? Motion carries. Ask you now to review the minutes from the March 12, 2013 meeting.
Paper this time instead on that iPad. Motion to accept the minutes has been presented.
Second.
Motion has been made by Mr. Hinkle to accept the minutes as presented, seconded by Mr. Starkey. All in favor, say aye.
Aye.
Any opposed? Motion carries. At this time, the chair will recognize Mr. Adrian Chick, Assistant General Counsel for the board.
Good morning, board members. May it please the board, you'll find a final order on your iPads, and if you flip through 2 pages, you'll come to an agreed order, and this agreed order is what I'd like to talk to the board a few minutes about, and ultimately I'll be asking that the board approve the agreed order. If this case had gone to hearing, the state's proof would have shown that Rick W. Green is a funeral director and an embalmer licensed by this board. He has been for quite some time, and the proof would have shown that in 2011 he was in a relationship with a woman that we'll just call Patricia. Apparently there was some alcohol abuse on the part of Mr. Green. The proof might also show that it was on the part of Miss Patricia as well. But anyway, their relationship apparently went sour, and at one point Patricia obtained an order of protection against Mr. Green. Mr. Green violated that order of protection by going to her residence, and as Patricia and her daughter were coming in from outside where their jacuzzi is, Mr. Green appeared and forced himself into the residence, and he had in his possession a firearm. He then proceeded to take them to a room where he barricaded them in the room. He consumed what appears to be some type of benzodiazepine medication, and several hours after that, as it began to take effect, the SWAT team was able to come in and get Mr. Green out peacefully. Nobody was injured. He was, of course, indicted, and ultimately that led to 2 felony convictions, which are in the allegations of fact. See that one conviction was for aggravated burglary, which is a Class C felony, and the other conviction was aggravated assault, which is a Class C felony. And the assault was aggravated by virtue of the fact that there was a firearm involved. So he pled to these and ended up doing about a year in the Department of Corrections, one of the stipulations to his judgments were that he would successfully complete a residential substance abuse program, which he apparently did, at which time he became eligible for release on probation. And last month, he was released from state custody, so he is out now. He's living in Sneedville with his parents. What I've recommended, I want to tell you what I recommended and then kind of explain how I got there. The recommendation is that this board would suspend his license for 1 year, a minimum of 1 year, which will start on the day that I file the final order. And after the completion of 1 year, he would have the opportunity to submit a letter from his probation officer to Mr. Gribble saying that he has successfully completed the terms of his probation, including any aftercare programs that were mandated. And if that's done, then his license would be automatically reinstated without having to come back before the board. His probation will continue, however, for however long the state probation continues. So if he is found by the board to have committed any violations during the 1 year period or during the period after that, then his license would be automatically revoked. Similarly, if there were a probation violation that's filed and sustained in the criminal court, that would result in an automatic revocation. And it also would require him to pay the cost involved in this administrative proceeding. As far as how I got there, the 2 felony convictions, as you know, the board has the authority when there's a felony conviction to suspend or revoke a license. The felony convictions are fairly serious. So I felt like they certainly warrant some type of significant discipline by this board. But on the other hand, they are not types of things that culminated from his professional practice. It's a domestic dispute, and I think those tend to be a little bit different than. I don't think a domestic dispute is necessarily indicative of how a person is going to interact with the public on a day-to-day basis. But anyway, doing this, I believe, would give him a chance if he wants to follow through on his aftercare and make a change in his life. It'll give the board a year to watch him and see how he does, and if he does well, then he would be able to come back to work in the profession. If not, then he stands to have his license revoked. But that's what I've proposed, and if there are any questions about it, I'll be glad to answer those.
Does he have possible employment if he's able to retain his license?
I don't know. Right now he's living with his parents in Sneedville, and I understand that he doesn't have any, he's certainly not employed in the funeral industry, so after this year I would hope that he would be able to find somewhere to go back. I believe there has been some funeral establishment that has assisted in keeping his licenses renewed while he was incarcerated, so that leads me to believe that there's at least one establishment that might look at him.
Dick, is
Excuse me.
Mr. Green here today?
No, Your Honor. That was the agreement, was that he would not have to come in from Sneedville, and I informed him and his attorney that if this is not accepted, then we'll have to set it for a hearing next month.
But you recommended that you add that he would have to appear before the board, before the...
I agree with you. I think he should appear before the board, too.
Are you talking about at the end of
Of the 1 year.
at the end of the year, and then
He
he'd
should appear
reappear
before the
before the board? Of course, this violates what you've agreed to, though, doesn't it?
Well, it does. That's, that would complicate things in that I've already got this drafted and he's had it signed, and that was one of the things that we talked about. If he did what he was supposed to do and provides certification from his probation officer, he was hoping he would not have to come back. And if he came back and has the letter showing that he's done everything he's supposed to do, then I would think the board is going to be okay with him anyway. So,
But he can't get reapproval unless he has the letters and stuff anyway. That
that's
he has to
correct.
submit.
If he can't provide certification from his probation officer, then he's going to have to come back here. So, if possible, I understand your concerns, but it would.
What's in the, what Mr. Neal and Ms. Sowell has addressed is under stipulated disposition, part of item number 2, looks like. Correct, Ms. Sowell, is that for you?
Correct.
Jack,
Yes, sir.
if you, like today, we have an applicant appearing, but anytime that, or not an applicant, but someone for reinstatement, anytime that they're required to appear, if they have met all their requirements, then the board has no leeway in deciding whether or not to reinstate the license. If they've met all the requirements, then it's automatically reinstated. Unless there's some reason that they violated something during the time that their license was suspended. I guess what my question is, does the board have the option whether or not to reinstate the license?
Well, nobody really wants to enter an indefinite suspension for understandable reasons. So we did write it as 1 year, and he originally wanted to backdate it, and I said no, it cannot be backdated. But I would say it's similar to people that apply. Normally people apply, and the same thing happens if they meet all the requirements, and there's no question about it. Robert approves the license, and many of those don't even come to the board except for, you're told after the fact what's been approved, and I think this is very similar to that.
What did he want? What did he want to backdate?
Oh, he was hoping that he could backdate his suspension to the time that he was incarcerated, and I informed him that was not an option.
You feel comfortable with this?
I do. I think it's
Motion to accept council's recommendation.
Second?
Motion has been made by Mr. Hinkle, seconded by Mr. Starkey, to accept the Assistant General Counsel's recommendation regarding the agreed order for Mr. Rick W. Green. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed?
No.
Ms. Moses, never mind. Let me think just a minute.
You can record Ms. Sowell as voting contrary to the conclusion of the matter.
Ms. Mosby, will the record show that the motion passes, but there's one contrary vote cast by Ms. Sowell, please? Okay.
Mr.
Do you have
President.
any other items to come before this board?
No, sir. May I present to you the agreed order, the final order?
We'll now recognize Mr. Bent McDonough with the Assistant General Counsel with his legal report.
President. The first complaint today is case number 2013000801.
Don, would you give us just a moment, please?
Yes, sir.
To regroup. Forward. Okay, thank you.
First complaint today is case number 2013000801. On September 27, 2012, a field representative conducted a routine inspection of the respondent establishment. The establishment license for the respondent expired on June 30, 2012, and was not renewed prior to the inspection. During that period of time, the respondent conducted 15 funeral services while in possession of an invalid license. We further note that the respondent has since renewed their establishment license. The respondent states that they sincerely apologize and states that the manager at the time was in poor health and was in the process of being replaced when the establishment license expired. The respondent assures the board that this will not happen again, and we found no history of prior complaints, and we're recommending a consent order with a $1,500 civil penalty and authorization for a hearing.
Based on 15 times 100.
Yes, sir.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 2 is case 2013000821, and number 3 is case number 2013000822. On August 28, 2012, a field representative conducted a routine inspection of the respondent establishment. Respondent number 3, who is neither a licensed funeral director nor an apprentice, has been meeting with families of deceased individuals in arrangement conferences without the benefit of a licensed funeral director being present in the room at the time that the meeting was taking place. Funeral directors employed by the establishment stated that they would occasionally check in during the arrangement conferences, but did not stay with the respondent during the entire arrangement process, a practice that has taken place for the last 2 years. Contracts are then completed by respondent number 3 and signed off by a licensed funeral director. We also found that the latest inspection report for the crematory utilized by this establishment was not available for inspection. On one statement of funeral goods and services selected, the description of merchandise must be supplied on the contract prior to the family of the deceased signing the document. Also, on one statement of funeral goods and services selected, the reason for embalming was not properly provided. In response, an attorney responded on behalf of respondent number 2. Respondent asked that the complaint be dismissed because the law only requires a licensed funeral director to be on the premises and not necessarily in the presence of a funeral director. The respondent states that the licensed funeral directors would go in and out of meetings while respondent number 3 met with families and were on the premises. Furthermore, respondent states that respondent number 3 was registered to sell pre-need funeral contracts and therefore was qualified to meet with these families. Another employee provided letters stating that respondent number 3 met with families and thought that under the instruction of a licensed funeral director, he could present funeral expenses to families on contract and have a licensed funeral director sign the contract at the conclusion of the meeting. The employee noted that they made the families aware of their presence on the premises during the arrangement conferences and allowed respondent number 3 to carry out the arrangements and merchandise selection and payment schedule. Further, this employee signed a statement admitting that they know this practice is now wrong. For respondent number 2, we found a history of 2 closed complaints, and respondent number 3, we found no prior complaints. And we are recommending for respondent number 2 a consent order with a $750 civil penalty and authorization for a hearing, and respondent number 3 a consent order with a $250 civil penalty and authorization for a hearing.
Quite a long time to do that, isn't it? It's never been caught before, or for 2 years he'd been doing it and it never had been caught.
They found it this time. That's all I can tell you at this point. I don't know about the previous inspections, what they.
People are knowingly violating the law. Licensed funeral directors, why aren't they waiting on the families?
Is this a branch situation? Or,
Care what it is.
well, I know.
I mean, excuse me, but
It's not a branch situation. The owner of the funeral home does own another location, but each one of them are full-service fully opened and operating funeral establishments.
The owner, a licensed funeral director,
Yes, ma'am.
and that's respondent number. The owner is,
Establishment is respondent number 2, and the individual in question, the unlicensed individual, is respondent number 3.
where's respondent number 1?
That one was not, we did not have a complaint open against. Asking about the owner? There was not one open against the owner. There's one open against the establishment.
Where's respondent number 1?
The way that we have these numbered on here is that respondent number 2 is, respondent number 1 in this case is a different complaint. We base the respondents on the numbers of the complaint, so there's no respondent number 1 in this case. There's respondent number 2 and
It's on
respondent number
different
3.
pages than I was.
Actually, there is no respondent one.
Makes it kind of confusing, but it's the only way to do it and do it anonymously, really.
Yeah.
But it does make it confusing.
Respondent number 2 is the owner
It's the establishment.
or the establishment.
Yes, ma'am.
Well, it's the establishment itself, Ms. Sal. It's not the owner individually. It's owned by an LLC. So the establishment,
Is the owner a licensed funeral director?
the individual who is a member of the LLC is a licensed funeral director.
For the audience out there, you see why we struggle with some of these things is because there's a whole lot of information that we're not legally told at this point. What you hear him read to us in our question back and forth, you can understand this board's position that we have a hard time struggling through some of these things sometimes. But they do a great job getting them together for us. Motion to accept council's recommendation.
States in there that he's a pre-need seller. A pre-need seller is 2 different animals from a funeral director.
He can sell pre-need funerals, but he's not supposed to be waiting on at-need
But
families.
This is not creative.
Right.
I know it, that's not pre-need. Is the penalty consistent with this normal type thing?
Penalties based on the fact that, based on the evidence that we have, that we obtained from the inspection. And so, based on the information that was provided to us from the field representatives, this is the civil penalty that we felt was appropriate in this matter.
In other words, Mr. Starkey, there's not evidence to substantiate that this has been happening for 2 years, although the allegation is that it's been happening for 2 years.
Okay.
The evidence is not there to substantiate it.
Oh, okay.
And that's the reason the
That's-
civil penalty is the recommendation is what it is.
Okay, I understand now. Okay.
Motion on the floor, is there a second?
One other question for, okay, sorry. Asked a question. Has this guy been told not to do this now, or will it be in that order that he is not to wait on families, or?
Well, they did say in the response that they're aware that what he was doing was improper and violated the funeral statute, so.
Respondent number, or in the response, further, this employee signed a statement admitting that they know this practice is now wrong. And that apparently is the unlicensed apprentice or the unlicensed?
Yes, that's correct.
Second to motion.
Now I have a motion on the floor by Mr. Hinkle to accept council's recommendation regarding complaint number 2 and complaint number 3. It's been seconded by Mr. Starkey. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 4 is case 2013000921. On May 2nd, 2012, the field representative conducted a routine inspection of the respondent establishment. Funeral director failed to sign the cremation authorization form in 2 files reviewed by the field representative. The latest inspection report for the crematory utilized by this establishment was not available for inspection. Also, the respondent's cremation authorization forms state that the crematory operator may inter, urn, entomb the cremated remains if not claimed within 120 days. However, state law requires that to read 180 days. Also, the current funeral director's license of 1 employee was not available for inspection. The current embalmer's license of 1 employee was not available for inspection. Following a review of 15 statements of funeral goods and services selected, it was discovered that the respondent's name listed at the top of the document referred to the establishment by name other than the exact name listed on the establishment application approved by the board. And a review of 9 statements of funeral goods and services selected shows that the merchandise and a description of that merchandise was not shown on the contract prior to the consumer signing the contract. In response, the manager was unaware that a funeral director had not signed the cremation authorization forms. Respondent is able to obtain a copy of the current inspection for the crematory utilized by this establishment upon request, and a hard copy will now be maintained inside the establishment. Respondent will change the documents to read 180 days as opposed to 120 days. The manager was unaware that the current licenses were not posted at the establishment and has now posted both the funeral director and embalmer's license. The manager was unaware that the name on the 15 statements of funeral goods and services selected was different than that listed on the establishment application, and the respondent has since corrected this oversight. And respondent states that although customers were in possession of a general price list at the time that the contract was signed, the respondent will now provide a description of the merchandise on the statement of funeral goods and services selected prior to the customer signing the document. We found a history of 2 closed complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Council, as a point of clarity, not necessarily in this complaint, but just in general before we move forward, we've seen the last several months several complaints regarding the disposition of cremated remains moving from 180 days from 120 days. Brief us on that, if you will. Apparently that has been a change in the rule or the law just recently, and we're seeing that being found, or is that an error that's been going on for quite some time?
I think it's an error that has been going on, and what I'm finding is that these are violations that have occurred from funeral homes that have been owned by the same corporation, and they have, I guess, software that prints off these lists, and so based on our findings, we're informing them that needs to be changed from 120 days to 180 days to follow state law that states that it can be done within 108, after 180 days instead of 120 days.
Gribble, do you have anything to add to that?
I think it could be that it was 180 days on the form at one time, and the company made a policy decision not reviewing the state law and changed it to 120 days. As you say, it's been occurring frequently lately, but
our rule has been 180 days all along.
Yes.
So apparently this is a
statute, not a rule. So it's been in place for some.
That statute's only been in for a little while, hasn't it? Didn't it come in with this last cremation stuff?
Not that I'm aware of. I think. Let me see.
apparently.
I was thinking before we couldn't really do anything with them until they changed the statute. We had limbo.
Apparently, this would have been probably a direction that came down from a corporate level stating 120 days, and our actual law says 180, so that would...
That amendment was added in 2010.
Okay.
Actually.
Well, that's what I'm saying. So this, in the last 2 years...
Relatively recently.
Yeah, it's fairly new, so I can understand, because I remember prior to that, we didn't really have any recourse if they didn't pick them up. We just kind of had to keep them in limbo until somebody said something. So that was put in there. So it gave us something to do with them,
Thank you, council, for that clarification. I didn't mean to get us off task, so we will, but I think we needed to, we've seen that a lot lately, so I want a clarification on that. So now let's continue discussion of complaint number 4, I believe it is.
History, you had one is dismissed in 1999, and then another one that was closed in 2005, and there's not been anything since then.
Not from our review of the history.
Motion to accept council's recommendation.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Neal, to accept council's recommendation regarding item number 4. Are there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 5 is case number 2013000931. On June 30th, 2012, a field representative conducted a routine inspection of the respondent establishment. Upon reviewing several statements of funeral goods and services selected, it was determined that the respondent failed to provide a description of the merchandise selected. The lack of description on the contracts appeared to occur only when a family selected some type of a service involving cremation. Also, the cremation authorization form of one individual failed to include the telephone number of the crematory utilized by this establishment. We received no response from this respondent, and we found a history of 9 complaints, 7 of those closed and 2 of them dismissed. And we're recommending a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750, and authorization for a hearing.
Long line of history, haven't they? Motion to accept council's recommendation.
Second.
Motion been made by Mr. Hinkle, seconded by Ms. Exile, to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
6 is case 2013000941. On June 30th, 2012, a field representative conducted a routine inspection of the respondent establishment. After reviewing a statement of funeral goods and services selected, it was determined that 11 contracts failed to provide a description of the merchandise selected by the consumer. We received no response from this respondent either, and we found a history of 5 closed complaints. And we're recommending a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750, and authorization for a hearing.
Make a motion to accept.
Second.
Motion made by Mr. Starkey to accept council's recommendation, seconded by Mr. Hinkle. Any further discussion? All in favor? Say aye.
Aye.
Any opposed? Motion carries.
7 is case 2013000951. On July 10th, 2012, field representative conducted a routine inspection of the respondent establishment. Following a review of statements of funeral goods and services selected, it was determined that on 7 separate occasions, the respondent failed to provide a description of the merchandise on the contract prior to the consumer signing the contract. Furthermore, the respondent failed to provide the reason for embalming on 6 separate occasions on 6 statements of funeral goods and services selected. Also, the respondent failed to provide the latest inspection report and current license for the crematory utilized by this establishment. And on 1 occasion, the respondent failed to have a licensed funeral director sign the cremation authorization form. The respondent states that the establishment is using new software, which led to several clerical errors and incomplete documentation in the files. As for the crematory violations, respondent states that these were oversights on the part of the manager, and respondent has reviewed all statements of funeral goods and services selected and made sure all documents are up to date. Found a history of one closed complaint, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Second.
Motion made by Mr. Starkey, seconded by Mr. Neal to accept council's recommendation. Is there any further discussion? All in favor? I'm sorry.
Ma'am, I'm fine with this, but I think we've discussed this before. Do these crematories accept these bodies and the paperwork if they're not signed by a funeral director? I realize that, but you don't have any way of knowing that.
Right.
But-
we can just go based on the documents that we received during the inspection.
And the field reps communicate with one another, like if the funeral home happens to be in one field rep's territory and the crematory's in another one, they'll email
check,
each
they
other
follow it up?
and they'll follow up with
Okay,
it.
all right, that's good.
Sometimes it's signed at the crematory. Their copy is signed, and the one at the funeral home is not, which would mean it's not a true copy of the document in those cases.
Original goes to the crematory. I mean, we use are multiple forms. The original.
Does the if not, that might be a good, so we would know when it comes. Sometimes these are crematories on the premise, and they're not really taking them to another crematory, you know.
Well, we maintain that those are separate entities, and even if they're owned on the premise, then there's got to be unless we've addressed that, and I was trying to think exactly how we've addressed it. But we've looked at that and addressed that, and it is in the inspection, and we've talked to legal counsel about it. I'd have to talk to one of the field reps to see exactly, but that's something they look at.
Field representatives do check and see in an instant.
You're not recording, Miss Sal.
Field representative does check and see and verify that the cremation authorization form, when it arrives at the crematory, is signed.
They go to the crematory. They do a check as well as they do at the funeral home. I'm not assuring you. I can't assure you that it's caught 100% of the time, but it is cross-checked and caught at different times. And then, of course, it'd be a violation against the crematory if they got a cremation authorization form that's not signed.
Ms. Sowell, it does seem hard to understand how that could happen, why it wouldn't be signed when it's right there before you, and it be signed in one place and not signed in another, but nonetheless, apparently that happens. Not to say that it's right, but apparently it happens. We have a motion on the floor that has been properly seconded. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 8 is case 2013000971. On August 6, 2012, a field representative conducted a routine inspection of the respondent establishment. On the general price list, the low end range on the casket price list was inconsistent with the general price list. Also on the general price list under immediate burial with casket selected from funeral home, the low end price is inconsistent with the price on the casket price list. The respondent's cremation authorization forms state that the crematory operator may inter, bury the cremains if unclaimed after 120 days. However, state law requires that this time be listed at 180 days. Also, the respondent was given warning when inspected on September 2nd, 2010, and a citation on September 13th, 2011, for signage not being in compliance with the name provided on the establishment application form approved by the board. Respondent was given an extended amount of time to correct this violation, but has failed to make this correction. Respondent states that the low-end range on the casket price list changed to match the general price list, and that immediate burial with casket selected from the funeral home is now priced consistently with the price on the casket price list. Also, all cremation authorization forms have been changed to reflect 180 days, and the name on the sign was pointed out in 2010, and a new sign was ordered. After waiting a year for the sign, the new sign was installed with the correct spelling in September of 2012, and a photo of the new sign was provided by the respondent. We found a history of 3 closed complaints in this matter, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Love to see that sign. Took 2 years to make. It must be really nice. Elaborate.
And carved.
Yeah.
Motion to accept council's recommendation.
Second.
Motion by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation. Are there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 9 is case 2013-001171. On May 22nd, 2012, a field representative conducted a routine inspection of the respondent establishment. A statement of funeral goods and services selected, signed, and dated on January 12th, 2012, was signed by an individual who was not a licensed funeral director. A business card listed 2 individuals as proprietors and owners, but failed to indicate that they were not licensed funeral directors or embalmers. Also, the embalmer's license for one individual was not available for inspection. On the general price list, the casket price range on the general price list was incorrect when compared to the casket price list. Direct cremation on the general price list lacked a price range. The immediate burial on general price list lacked a price range. Direct cremation with container provided by customer had incomplete disclosure. The immediate burial with container provided by customer lacked a disclosure. As far as the casket price list, no alternative container for direct cremation was listed on the casket price list. Cloth-covered casket offered as option on immediate burial was not listed on the casket price list. And 2 caskets offered for sale in the selection room were not listed on the casket price list. On the outer burial container price list, the Venetian outer burial container must include description on the outer burial container price list. The price of the Doric tiara sample displayed in selection room was incorrect when compared to the price on the outer burial container price list. The price of the Wilbert cameo rose was incorrect when compared to the outer burial container price list. The Athenian vault was offered for sale in the selection room but was not listed on the outer burial container price list. The concrete box offered for sale in the selection room was not listed on the outer burial container price list. And the wood box offered for sale in the selection room was not listed on the outer burial container price list. Also, we found 4 statements of funeral goods and services selected that did not provide the reason for embalming when a fee for embalming was charged to the consumer. And also 4 statements of funeral goods and services selected did not provide a description of the merchandise selected. The latest inspection report and license for the crematory utilized by this establishment was not available for inspection. And we found that 1 body failed to display a permanent identification device. Also, the field representative observed a body in a casket in the preparation room. When the field representative inquired, he found that the body had been there for 5 months following funeral services in December of 2011. The decedent's family could not or would not pay the funeral bill, and therefore the respondent kept the body in the preparation room and told the field representative that they were not sure how long they would keep the body in the room. Upon examining the body, the field representative found that the body was beginning to show signs of deterioration and provided pictures to reflect this finding. Upon leaving the funeral establishment, the field representative was contacted by a licensed funeral director on staff and informed that the body would be buried later that day at a local cemetery. The field representative witnessed the burial and confirmed that it was the same decedent seen in the preparation room. In response, the respondent's manager stated that these violations occurred prior to his time on staff and forwarded the pertinent documents to the previous manager, who later responded to the violations. The previous manager was replaced in May of 2012. The manager stated that the field representative provided 2 findings of concern. Those were issues with the price list, which have been corrected, and an unlicensed employee signing the statement of funeral goods and services selected, which later led to the dismissal of this particular manager. The manager states that she was not made aware of the other violations. As for the failure to bury the deceased individual found in the preparation room, the manager states that she informed one of the funeral directors that the body should be buried, but the funeral director asked for more time for the family to raise the appropriate funds. The manager states that she was only told of the 2 violations and would like a letter from the respondent stating that she was never made aware of the additional violations. We found a history of 7 closed complaints and 1 open complaint in this matter, and we're recommending a consent order with a $1,000 civil penalty and authorization for a hearing.
Make a recommendation, we accept council's recommendation or motion.
I don't think $1,000 is enough for everything that they did.
I'd really like somebody, they kept a human body in a prep room for 5 months. Prep room air conditioned?
Yes.
It is air conditioned, okay. Okay. I have to ask that question is, I'm not a funeral director or an embalmer. I'm the consumer of one. And when I think about a body laying there, I'm sorry.
Somebody needs to go to school, too.
Well,
Motion on the floor. Is there a second?
second.
Is there obviously in these other, how many? 7 complaints that were 1 or 2 that were closed, but there's significant situations in those too. Is there any indication that these problems are going to be corrected? I mean,
I agree with you.
The penalties in the past don't seem to have.
I agree with you that they seem that it's a
anybody's
whole lot
attention.
easier for them to pay the penalty than it is correct the problems. And I also agree with Mr. Dollars, but based on what's been presented, that's the reason I made my motion.
Here they paid $3,350 in fines since 2007. Not closed or dismissed.
Yeah.
They're a firm that does, in 2011, they did 56 calls. That's the size operation they have. They have appointed a new manager. I don't know whether Ms. Allen answered your question. Hopefully that will help.
Do you know when that manager came on board?
The new manager came on board. It appears the manager that was in place during this time left in May of last year after this inspection.
Excuse me, May 2012, according to this response.
Be time to do another inspection soon at their facility.
Motion on the floor by Mr. Starkey, seconded by Mr. Hinkle, to accept council's recommendation. All in favor, say aye.
Aye.
All opposed? Motion passes.
Number 10 is case 2013001211. On July 16th, 2012, a field representative conducted a routine inspection of the respondent establishment. The board lists this establishment as a sole proprietorship and lists the name of the owner. However, the owner passed away in 2007 and has been replaced by another individual, but the respondent failed to provide notice of this change. Also, neither the current license nor the latest inspection report of the crematory utilized by this establishment were available for inspection. A licensed funeral director failed to sign the cremation authorization form of one customer, and the respondent failed to provide a description of the merchandise selected on 4 statement of funeral goods and services selected. Respondent failed to provide the reason for embalming on 2 statements of funeral goods and services selected where charges for embalming were recorded. On the general price list, the high-end range for direct cremation is inconsistent with the casket price list. Also on the general price list, the direct cremation with fiberboard container found that the price was inconsistent with the casket price list. And on the casket price list under alternative containers, the fiberboard box is inconsistent with the general price list. Respondent states that the paperwork was available, but they were unable to find it to provide it to the field representative during the inspection. And we found a history of 3 closed complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Ownership situation been satisfied with the office?
Well, sometimes we don't, it's hard to find out sometimes if, like, there was a sole proprietor that owned this, and it was a person who was not a funeral director. So sometimes it's hard to know that an owner's died. You have to check several things, and sometimes we don't find that. The field rep doesn't find it as quickly as, and it could be
People
too.
just didn't report it.
He didn't. The current owner did not report the death of the sole proprietor. Also, sometimes the field rep may have given them a warning in times past, and they didn't do anything about it, and then this time is the reason they opened the complaint.
They have a business license? Wouldn't they have to have?
I'm sure they do. I don't know. I can't verify to you that they do, but I'm sure that they probably do.
Well, they have to verify, they do verify it when you go in business, so, I mean, you have to turn all that in, so at some point, legal. When they opened, they were legal. President, where are we at on this one? Has anybody made a motion? No. I make a motion.
Motion made by Mr. Starkey, seconded by Mr. Hinkle.
Second.
To accept council's recommendation regarding complaint number 10. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 11 is case 2013001271. On July 5th, 2012, a field representative conducted a routine inspection of the respondent establishment. The chapel where services are conducted in the arrangement office and the main hallways all had noticeable leaks and water damage. The latest inspection report for the crematory utilized by this establishment was not available for inspection. Upon checking one deceased body, already dressed and casketed, it was determined that the respondent failed to affix a permanent identification device to the body. And on one statement of funeral goods and services selected, it could not be located at the time of the inspection, showing a reason for embalming or description of the merchandise selected. Respondent admits that there are issues with the roof and it needs to be repaired. However, they are unable to pay the cost to have the roof replaced at this time. Furthermore, the respondent attempted to allow other establishments to use this location for their funeral services, but one establishment used the location without paying what the two businesses had agreed upon. Respondent has since displayed the inspection report for the crematory utilized by this establishment, and the respondent was not aware that their embalmer failed to affix a permanent identification device to the decedent, but they have taken steps to address this issue in the future. The decedent's paperwork was not at the funeral home during the inspection, as the funeral director was meeting off-site with the family and had yet to return the file to the establishment. We found a history of 6 closed complaints with this respondent, and we're recommending a consent order with a $250 civil penalty, and within 30 days, the respondent should provide a timeline and plan of action for repairing the leaking roof and authorization for a hearing.
Is that 250? ID device, is that what?
Various findings, such as I know the inspection report for the crematory was not available at the time, and also the permanent identification device was not affixed to the body. So we felt that, you know, this is a respondent that we've had issues with before, and you know, I believe that they have tried to find some way to fix the roof, and so I thought if we assessed a $250 civil penalty and then just had them provide us with some sort of timeline as to, you know, or some kind of plan to fix the roof, that would probably be the better plan of action in this case.
According to complaints in 2010 and 2011, the roof was leaking then.
That's correct.
Complaints. So they still hadn't. They were cited on those 2 occasions, and they still hadn't done anything about it.
They didn't repair it within the timeline. Is there anything this board can do to pull an establishment license?
I would think so. I would think it would be.
Motion, we accept council's recommendation.
Second.
Motion has been made by Mr. Neal, second by Ms. Sowell, to accept council's recommendation regarding item number 11. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. I am glad that this funeral establishment that was inspected does have a chapel and an arrangement office and a hallway that can be inspected. I'll leave that word. Number 12, council.
Why would anybody else want to rent it? He said they didn't pay for it, and I can understand why they didn't.
I'm with you.
Number 12.
Well, it's case 2013-001281. On July 10th, 2012, a field representative conducted a routine inspection of the respondent establishment. On the outer burial container price list, the respondent listed the Wilbert Monticello at $1,325. However, on the statement of funeral goods and services selected in 14 instances, the respondent charged consumers $1,375, creating an overcharge of $50 each, or a total of $700. The respondent states that at annual price change time, the respondent states that they go to great lengths to remain accurate on their price list. The price in respondent's computer system was incorrect in the system, and they changed the pricing on the price list. Respondent sent out apology letters and refunds by July 12th, 2012. We found a history of 1 closed complaint and 1 open complaint involving the respondent, and we're recommending a letter of warning in this case.
Move approval.
Second.
Motion made by Mrs. Sowell, seconded by Mr. Neal, to accept council's recommendation. Any further discussion? I will commend them on their prompt action. All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 13 is case 2013-001361. On July 11th, 2012, a field representative conducted a routine inspection of the respondent establishment. The board has this establishment listed as owned by a person other than the current owner. There's been an unreported change of ownership which took place on October 26, 2010. Respondent incorporated a new business in 2010 but never changed the name from its original name with the board. The shareholders of the corporation are actually the same, and there has been no change of ownership, and the responsible parties have remained the same. We found a history of 8 closed complaints, and we are recommending a letter of warning in this case. And actually, Mr. Gribble and I met with the attorney for this respondent, and they have informed us that they're going to provide us with the proper paperwork for the ownership change, and so that's why we feel that letter of warning in this case is appropriate.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
14 is case 2013-001381. On July 20th, 2012, a field representative conducted a routine inspection of the respondent establishment. The general price list, casket price list, and outer burial container price list are viewed by the public and fail to refer to the funeral establishment by the exact name listed on the establishment application approved by the board. The latest inspection report and license of the crematory utilized by this establishment was not available for inspection. On the general price list, use of facilities and staff for viewing must be corrected. Also on the general price list, the alternative container for direct cremation disclosure was not correct. On the statement of funeral goods and services selected, on one occasion the respondent failed to provide a reason for embalming. And also on the statement of funeral goods and services selected, the outer burial container price list and the statement of funeral goods and services selected did not match on 2 contracts where a Wilbert concrete outer burial container was selected. Also, the copier used by this establishment was unable to produce the required paper size at the time of inspection, and the statement of funeral goods and services selected copies were not made on legal size paper. And we found no response from this respondent in this case, and we found a history of 5 closed complaints. We're recommending a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750 and authorization for a hearing.
Make a motion, we accept council's recommendation.
Second.
Motion made by Mr. Neal, seconded by Ms. Owl to accept council's recommendation. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Case 2013-001421, on July 24th, 2012, a field representative conducted a routine inspection of the respondent establishment. One cremation authorization form was not signed by a licensed funeral director. In the preparation room, personal effects of deceased were left on counters. Towels and aprons were not put away properly. Open products were left out on counters. The embalming table had soiled laundry, instruments needed to be cleaned, and surfaces needed to be cleaned as well. Also on the general price list, the consumer's right of selection disclosure must be corrected. The outer burial container price list disclosure must be corrected. The immediate burial with casket selected from the funeral home priced at $1,895, which is inconsistent with the casket price list of $2,890. Also, the traditional funeral service without limousine, the individual prices do not add up to the total package cost, making the prices inconsistent. The traditional funeral service with limousine, family car, individual prices do not add up to the total package cost, making the price inconsistent. And the direct cremation with cremation casket selected from our funeral home, the price is inconsistent with the casket price list. In response, the establishment went through abrupt change in the week prior to the inspection. All issues were addressed quickly following the inspection. Random audit of files conducted, preparation room was thoroughly cleaned, and a new management has implemented checks and balance system to ensure proper cleaning and disinfection. And also the general price list has been reviewed and all changes requested have been completed. We found a prior history of 4 closed complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Well, there's been a management change in this instance as well.
Yes, ma'am.
Is that the abrupt change?
Yes.
Okay.
Move approval.
Second.
Motion made by Ms. Sowell, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
16 is case 2013-001431, and number 17 is case 2013-001432. On August 16, 2012, a field representative conducted a routine inspection of the respondent establishment. The funeral director's license of one individual, who is the listed manager of this establishment, expired on June 30, 2012, and was not renewed until July 8, 2012. Furthermore, this individual's Embalmers license expired on June 30, 2012, and was not renewed until July 8, 2012. The establishment conducted 2 funeral services while this individual was in possession of expired licenses. During the inspection, the funeral director's and Embalmers licenses of the same individual were not available for inspection. Also, on the general price list under direct cremation, the low to high end range of prices on the casket price list was inconsistent with the general price list. On the statement of funeral goods and services selected, the cost of services must be consistent with the general price list. However, one file was charged a price for direct cremation that was inconsistent with the general price list. And on all statements of funeral goods and services selected, merchandise and its description must be added before the contract is signed by the consumer. However, it was determined that the respondent failed to do this on 2 separate occasions. In response, respondent stated that he did not provide funeral services or embalming services to any customers while his funeral director's license and embalmer's license were invalid. Respondent states that he allowed the licensed funeral directors and embalmers to provide these services, but he was unaware that the establishment was not allowed to provide services while his licenses were invalid. Respondent could not provide a copy of his license during the inspection due to the expiration, and the price ranges on the price list were unintentional, and steps have been taken to address the violation in the future. For respondent number 16, we found a history of 2 closed complaints and 1 dismissed complaint. And for respondent number 17, we found no prior complaints. And for respondent number 16, we're recommending a consent order with a $250 civil penalty and authorization for a hearing. And respondent number 17, a consent order with a $250 civil penalty and authorization for a hearing.
Funeral rule were the one file, it's the second item. Charge for direct cremation was inconsistent with GPL. Was that a higher cost or a lower cost?
I didn't see that in the file, but let me check.
My
just to
question
make
is,
sure.
was somebody due some money back?
Appears to be an overcharge of about $230, which we can find that. We typically add that into the cover letter that they should refund that money and provide us verification that refund was made. So I apologize for that oversight on there.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
I noticed we've had quite a few over the last several months. License expires June 30th, and almost every one of them, the license has they've got their license back, say, before the 15th, it's in that first 15 days. You've got July 4th in there. Of course, I know you're supposed to have it in, I guess, way early. But is there a possibility sometimes it's crossing the mail, the office is closed? I mean, how does that, or is that when it came in for renewal?
Came in for renewal. Only renewal notice when we send it out, we do two things. We ask them to renew online. If they elect not to renew online, then we ask them to mail it at least 15 days prior to the expiration date of the license. When the money is first hits the state, whether it's the Revenue Processing Center here at the department, or whether it's the Department of Revenue, that's where the pre-addressed envelopes actually sends that money to the Department of Revenue. They process it and send it down, but they date stamp all that. So whenever that means when it first hit the state, it doesn't matter whether or not it actually got to the board office that day. It's just when it first came in receipt by the state. And also, if June the 30th happens to be on a Saturday, Sunday, or a holiday, which July the 4th soon after, it's not. They're not penalized for. They're allowed to the next working day, without any penalty. We had that to happen recently with what holiday do we have recently? Anyway, we had a recent one where
Good Friday.
Good Friday. Anyway, we had that to happen lately to where we were closed on a Friday. We had a license that was supposed to have been renewed by that date. We were closed. It was delivered on Monday, and there was no penalty. They didn't even have to pay the penalty or anything. There was no penalty at all.
Just noticed a bunch of them through the last several months. It'll seem to be get their license back within 10 to 12 days after they expire, but
Sometimes it can be continued education, too.
Yeah.
They think they get continued education, then once they send it in, they find out they don't have continued education. They have to end up getting this continued education back into the state in order to get the license back.
that's correct.
And I believe on the website, up next to Mr. Gribbles' smiling face over to the left is something about is your license expired or something. I noticed that on our website. Reminder.
We encourage everybody to renew online. It does cost a small fee, but it's no more than when you send it overnight through whatever overnight service you use, and that's live time. And also those are worked the very first thing the next morning. If somebody pays online, they don't have continuing education, then one of the administrative assistants types a letter, puts in the mail to them, and also faxes that letter to their last place of record of employment. That's why it's important if they move from one establishment to another one, they let us know so we can keep their records updated, just like their mailing address. And if they, say for instance, the money comes to the state on June the 28th, and the administrative assistant sends the letter, faxes it to them, and they do the continuing education on June the 30th, then there's still no penalty. They have met the requirements to comply by June the 30th, even though it may not actually be renewed in their system, but then they've met all the requirements and they pay no penalty. Now, if they wait till July the 2nd to do the continuing education, then there's a penalty. That's why if they pay ahead of time, it allows more time for us to catch those things.
Yeah.
And then sometimes when they send it through the mail, they don't fill out the back side of the form, or they don't sign it, and we have to send it back to them. So that's why we say 15 days, is to allow once for us to get it, and if there are any problems, to let them know about them before their license actually expire.
Remember in the old days, even though they were due on a certain date, they told us not to send it in till after that date because the state closed the books out, and then they took all the money that was there ahead of time, so the board didn't have it to operate on. So I don't know if that was in your day or not, but you may remember what I'm talking about.
Now they're trade secrets.
Yeah.
I don't remember that.
Yeah.
But you told me you were having a birthday in a few days.
Yeah, all
and
right,
it's a day or two. It's a year or two older than mine, so I
Yeah,
probably
so
almost remember it, but not hardly.
Yeah. Well, anything in the fund, I think, they close the books June 30th. Anything in the fund up to then went in general fund and took it away from the board. And so they told us, don't send your money in until after the expiration date, because then that way we get to keep it in the board, for the whole year to operate on. If you do it before, then it goes in general fund.
That's changed now. It's,
Yeah.
It doesn't matter when we get the money; it's accounted for.
Okay.
And
Folks, y'all heard what he said. It's changed now. Don't hold the money.
Back to you, Mr. Counsel.
Thank you, Mr. President. Number 18 is case 2013-001-441. Number 19 is case 2013-001-442. And number 20 is case 2013-001-443. On August 15, 2012, a field representative conducted a routine inspection of the respondent establishment. The funeral director's license for the manager of record expired on June 30, 2012, and was not renewed until July 12th of 2012. During this 12-day period, the individual remained as manager during a time in which 11 funeral services were performed by the establishment. One deceased individual was found in the chapel dressed and casketed for his services to begin. However, there was no identification device affixed to the body. Upon request to review the records of 2 customers, the field representative noted that all of the statements for the 2 individuals were not available for review. And also, the reason for embalming was not provided on 2 statements of funeral goods and services selected, reviewed by the field representative. The manager failed to fulfill their continuing education requirements. The manager sent their license renewal several weeks in advance of the expiration date, but they were unaware of the continuing education shortage until receiving notice from the board. Respondent states that they met the obligations on July 7, 2012, but that their license was not renewed until July 12th of 2012. As far as the prior history goes, for respondent number 18, we found a history of 3 closed complaints and 1 dismissed complaint. For respondent number 19, we found 1 closed complaint, and respondent number 20, no prior complaints. We're recommending for respondent number 18 a consent order with a $1,100 civil penalty and authorization for a hearing. For respondent number 19, a consent order with a $500 civil penalty and authorization for a hearing. And respondent number 20, we're recommending dismissal.
Make a motion we accept council's recommendation.
Second.
Motion made by Mr. Starkey, seconded by Mr. Hinkle to accept council's recommendations. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries.
Number 21 is case 2012-023-811. This complaint was actually filed by a consumer and originally heard during the February board meeting. On October 16, 2012, the decedent passed away following open heart surgery and was taken to the respondent funeral establishment. The decedent's husband and children went to make arrangements, but there was an issue obtaining the insurance policy, so the arrangements remained incomplete. On October 18, 2012, the decedent's family went to the funeral establishment to fix the decedent's nails and hair, and the family was led to the chapel where the decedent was placed on a table with a sheet draped over the body. The drain alley still had blood puddles in it, and there appeared to be blood clots hanging out of the drain hose at the foot of the table. Furthermore, the only place where the family could wash up was in the public restroom. On October 19, 2012, the family arrived 2 hours prior to receiving friends. There was very minimal makeup applied to the decedent's face, and there was no mascara. The lipstick stopped at the nose line, and dark bruises were evident on the decedent's body. There was no makeup applied to cover the trauma to the decedent's neck. There was blood-soaked cotton covering the site where the blood was drained, and there was a suture lying on the decedent's blouse. Also, no undergarments were under the blouse, and the cotton covering the surgical incision was very visible, and the decedent's underwear was not pulled up completely. The daughters asked that the makeup be reapplied, and the complainant killed at least 6 gnats that came out of the casket during the viewing. The daughters applied mascara to the decedent, and the employee didn't even offer to provide the service, and a niece went to a local store to purchase a scarf to cover up the decedent's neck. The funeral home was too warm, and the decedent's color actually darkened in the 6 hours while the family was present. On October 20th, 2012, there was very little organization from the respondent. The employees almost pushed the casket off the stand as they were moving the casket from the viewing room to the chapel. No one was directing traffic, causing the daughters to be last in line to the cemetery. And the complainant touched the decedent's body and found it to be soft, which she thought was odd for the body that had been embalmed. In response, the respondent states that on October 17, 2012, the decedent's family met with the respondent's employee to discuss final arrangements, but they were not sure how they planned on paying for the funeral until they located an insurance policy later that afternoon. On October 18, 2012, the family arrived to fix the decedent's hair. The decedent was placed in the chapel because the respondent employee believed it was a better environment for the family to provide hair care. The respondent employee explained to the family that the decedent was in the chapel and that the body was covered with a sheet. The sheet was placed to cover the drain tube, and the respondent admits that they should have lifted the sheet to see if the drain tube was dirty. On October 19, 2012, the respondent employee did not provide the initial cosmetic application. However, she believed the person who did the cosmetics did a good job. The employee wishes that she had looked over everything to make sure all the details were properly addressed. Family said that they were not happy with the lipstick, so the employee offered to try and fix the application of the lipstick. While the employee was working on the lipstick, the family asked that she cover the bruises on the decedent's face as well. The employee states that this was a difficult case as the decedent's entire arm was exposed due to her wearing short sleeves. The employee was unaware of the difference in color in the hand and the arm, but stated that this difference could be due to the amount of makeup applied to the arm. The employee did not offer to apply mascara to the decedent, as no one asked her to do that, and she would have gone out and purchased a scarf if the family had made her aware of the condition of the decedent's neck. The family gave the employee very specific instructions that they would view the decedent's body and then close the casket for the funeral service as the decedent had requested. However, the family asked that the employee leave the casket open as they informed her that the decedent looked so nice. As for the temperature in the establishment, the employee states that she was unaware that the family was uncomfortable with the temperature in the establishment. On October 20th, when moving the casket to the chapel, the employee was unaware of any issues during the transportation, and nothing out of the ordinary of moving the casket had occurred. As for the transportation to the gravesite, the employee states that some family members preferred to walk while others drove to the gravesite, but that they allowed any family member who wished to drive to the gravesite to park their cars behind the hearse. The employee states that she worked very hard to address the concerns of the family and asked on numerous occasions whether the family needed any assistance. However, she regrets that there may have been some issues with leakage from the decedent's body caused by the presence of edema. On an additional note, on November 19, 2012, the board received a letter from the manager of the respondent establishment stating that they were refunding the family $1,365, the total cost of the embalming and dressing of the decedent. We found a history of 3 closed complaints, none related. We previously recommended a letter of warning, but also the board asked that we contact the family who filed the complaint and send the letter of warning to the respondent if the family is satisfied with the refund that was provided by the respondent. After speaking with the family, council has determined that the family is not satisfied with the response. Therefore, a consent order with a $1,000 civil penalty and authorization for a hearing appears to be appropriate in this matter.
Did they actually mail the check to the family?
Yes, they did.
Employee, that is referred to in this instant, a licensed embalmer?
I'm not sure about that off the top of my head.
Complaint is against the establishment.
That's correct.
Oh, only.
The complaint that we're hearing today, yes, ma'am, is filed against the establishment. Family has received a refund of $1,365, but apparently they feel that
Motion to accept council recommendation $1,000 penalty, civil.
Is there a second?
Is the employee that's referred to in this complaint, apparently they dealt with one person. It sounds like they're dealing with the same person all throughout on these several days.
Yes, ma'am.
Do we know if that person is licensed?
I can't tell you that right now. I'm not aware of that. I believe the person that responded in this matter was the manager of the establishment. Now, whether or not that individual has an embalmer's license, I'm not sure.
For a hearing, maybe we can ask more.
Motion fails for the lack of a second. Is there any further discussion regarding complaint number 21?
Is there any, can you elaborate on the dissatisfaction of the complainant with the response?
From speaking to the complainant, I think, I know from the previous presentation of the case in February, I think the board had issues with the fact that the drain tube still had blood clots that were visible draining from the tube, and that it was in the chapel, and that seemed to be a significant focus by the complainant on the complaint was just with the issue of so much the placement of the body in the chapel and the drain tube and the condition that it was. And so I know that you all initially asked for a letter of warning, but you also wanted me to check with the family to see if they were satisfied with the response, and if they weren't, then I was to represent that, and so I'm representing it today following my conversation with the complainant to get a feel of how they perceive the return of the $1,300 from the respondent and the letter of warning that was proposed by the board.
My concern is unprofessional conduct.
But you're referring to the manager, not the
Referring
establishment.
to whoever's dealing with his family on these 3
It'll be the
days.
manager.
It appears that way.
I think we need to, there's something about unprofessional conduct. I think they need to be cited for that.
Almost it.
Family needs to know that we're recognizing that there was indeed unprofessional and unethical conduct in this instance, if it's verified.
If you all do adopt a consent order in this case, then unprofessional conduct would be the main statute that I would cite in this matter.
You want to go after the manager or the person that waited on this family plus the establishment's what you're saying.
Might be one and the same, but yes.
I agree with her.
I mean, there's
This
unprofessional conduct all the way around.
Yeah, the employee, said this, the employee said that.
Well, the situation today, though, is strictly against the establishment. So we can only focus today on the establishment. We can't take up any matter against the manager. This specific complaint pertains specifically to the establishment and not some other individual. So for purposes of today, the board would just need to decide whether or not they're going to take action against the establishment, and that's the extent of the action that would take place today.
almost a case that they said, he said, they said, because the family first wanted the casket closed, but they said the body looked so good that they wanted to leave it open, but then they say it turned, so I mean, it's backwards and forwards. So I have a problem. I've seen cases before sometimes, and unfortunately, most of the time when you have a case like this, it's a family that didn't have money, and so they're starting to complain, because they haven't.
The specifics of that they mentioned in this complaint regarding the body: underclothes not being there, they're not being properly done, the incision that was referred to, the bloody condition thing. This is not something people would make up. I mean, they had to see that or they wouldn't have mentioned it. And that's what I mean, I think the evidence is there that this occurred.
With the consent order and a civil penalty assessment would give the establishment the opportunity to either admit their guilt and pay the penalty or request a hearing.
That's correct.
Second the motion.
We don't have a motion.
We don't have a motion.
No,
yet?
we did.
The motion failed for the lack of a
Lack-
second, so
okay.
we're back
I
to
beg
discussion
pardon.
phase.
Now, can I make a motion
Need to come
again
in
now
a-
that
It need to come in a new motion.
I make a motion that we accept council's recommendation?
Second.
Which is a consent order, $1,000 civil penalty and authorization for a hearing. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? I want to thank you for your legal report and for the hard work that you put in since our last board meeting. We appreciate that very much. In consideration of that length of that report, the chair will ask for a 5-minute recess, please.
Thank you.
What time is it?
Recess is concluded, and we will reconvene the board meeting of April the 9th, 2013. Chair now recognizes Mr. Robert Gribble, Executive Director, to discuss administrative matters.
Thank you, Mr. President. A couple of things. You'll recall a group of 3 individuals being here the last time that made a presentation to you regarding alkaline hydrolysis, and that the board made a motion and passed it unanimously, asking the sponsors of the House and Senate bills to delay action on that this legislative session and give all interested parties time to meet and talk and before next year's legislative session. And at the conclusion of the meeting, Mr. McDonough prepared a memo and sent that to the department's legislative liaison, and it was later delivered to those House and Senate sponsors, and they agreed to do so. So just to update you on that they sponsors agreed to what the board had requested. So there may be some time later this summer or this fall when there'll be groups that gather regarding alkaline hydrolysis and legislation for next year. Also, the president had asked me about the past presidents lunching and honoring the board members that concluded their time December 31st of last year. We have a tentative reservation to do that next board meeting, which would be May the 14th. Normally do that at 12:30. That way, if you have a fairly routine board meeting, you're concluded by that time, and if there's a formal hearing, then you just normally take a lunch recess from about 12. We need to leave here by 12:10 in order to get there on time, 12:10, 12:15. So if you have a formal hearing or a longer board meeting, probably just have to take a little bit longer than usual lunch that day. Now, there's only one problem with that. One of the people we're to honor is Mr. Hinkle. It's hard to honor someone who's still with you, so I don't know whether that will be addressed before the next meeting or not. But I'll be in conversation with the president to get his direction on what he wants done, and just let you know that there's a possibility that it would be next month.
We will tell him he only gets one lunch.
Since you pay for it.
Well, the thing of it is now, I think
You have to lean up, Mr. Hinkle. You got to lean up.
mics are hot. I'm sorry. Never mind. I'll talk to you later about who pays.
And
Heard that before.
as far as the licensee report, there's a report of licenses administratively approved by the executive director pursuant to the board's authority for the period of March 12, 2013 through April 8, 2013. You have the first establishment there. That is a name change, but also for your information, they've actually added an on-site crematory. And those individuals listed below there, and whether they have received a funeral director and embalmer's license or a funeral director's license. Disciplinary action report for this board meeting is as light as I have ever seen, I guess. It's a report of consent orders administratively accepted and approved by the executive director pursuant to the board authority for the period of March 1 through March 31, 2013. You have one consent order. Complaint report. As of yesterday, there were 121 open complaints. You can see there in the various categories and who filed those complaints, and so we have a total of 6 against funeral directors and embalmers and a total of 115 against funeral establishments. There were no closed establishments that have reported since the last board meeting, so we have no closed establishment report today. And Mr. President, that concludes my report.
Thank you, Mr.
President, may I answer a question?
Absolutely.
Ask a question, excuse me. On the disciplinary action with this one, that means that's the only establishment to which disciplinary action had been, that has complied. Is that correct?
What happens when the board authorizes the consent order of the civil penalty, then general counsel will send that out. That just happens to be the only one that came back in during the month. Sometimes it's just there's no system to it. Sometimes we get 6 or 8 consent orders just right before the end of the month. This time we got several right after the first of the month, so they'll be reported to you on the April disciplinary action report.
Thank you.
It just happened to be that was the only one this particular month.
Thank you, Mr. Gribble, for your report. The chair will entertain a motion to accept Mr. Gribble's administrative matters report.
Make a motion to accept.
Second.
Motion by Mr. Neal, seconded by Mr. Hinkle. All in favor, say aye.
Aye.
Thank you, Mr. Gribble. The board will now consider approval of license applications for individuals and establishments. Mr. Gribble, are there any to come before us today?
Yes, sir. There are no establishments, but there are 3 individuals. Mr. Martis, if you'll just come and have a seat. We've determined that the microphone there picks up better, and if you'll just pull that mic kindly down toward you, that would be good. Mr. Matthew Kenneth Martis of Olive Branch, Mississippi, is applying today for a funeral director and embalmer's license. And based on the applications, we have informed him that the board may review, among other pertinent statutes and rules, the Tennessee Code Annotated 62-5-317, and making a determination today as whether or not the applicant meets the requirements for licensure. He has all of his requirements as far as apprentice, passing his exams, and all those things are complete.
Give the board a moment to look over Mr. Martis's application. It'd be the first set under approval of license applications. Matthew Kenneth Martis, excuse me. Give you an opportunity to look over his application. discussion of Mr. Martis's application.
This instance that you refer to happened in 1999.
Yes, October the 3rd.
1999.
I believe the only issue I had since then was while I was deployed, I got a jury notice, which had to be taken care of. Obviously, I couldn't be there. I believe is the only other.
All the requirements other than that issue.
Yes, sir.
Motion to approve the licensing.
Second.
Funeral director's license and an embalmer's license.
Motion has been made and seconded to approve license application of Matthew Kenneth Martis for both funeral directors and embalmers. Motion has been made by Mr. Hinkle, seconded by Mr. Starkey. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Mr. Martis, congratulations.
Go get your piece of pumpkin pie.
Something about a pumpkin pie. Y'all been talking about eating pumpkin pie somewhere? I keep forgetting these mics are on.
You didn't read what his charge was.
Larceny.
Next is Mr. Brett Estes Brown of London, Kentucky, who is applying for funeral director and embalmer's license by reciprocity. And the reason that Mr. Brown is before you today is for you to look at specifically TCA 62-5-311B1 and 3, and also Rule 0660-2-023. And what all that says is that he's been licensed since 1991 in Kentucky. At the time he took the National Board exams, those exams were combined, and you got to pass or fail based on the average of the two exams. He made 74.8 on his arts and made 82 on his science exam. Average those together, that's an overall average of 78.4, which at that time was considered passing. We have a statute and a rule that says you shall make at least 75. In the past, and Assistant General Counsel may want to speak to this, but in the past, it's my understanding that counsel has advised the board that you have some leeway in the determinability of that, and if it's 74.5 or more, you may decide you want to grant the license based on his history. But like I say, counsel may want to speak to that.
And we've had something similar like this before, where it was.
4 or 5 months ago, 3 or 4
Yeah.
months ago, we had a person that was in the same.
Make a motion we accept.
I second it.
And you're making reciprocity from Kentucky, is that correct? And you employed as a funeral director or embalmer there for how long?
22 years. Licensed for 22 years.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle, to approve the application for funeral director and embalmer by reciprocity for Britt Estes Brown. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Mr. Brown, the motion carries. Congratulations.
Next is Ashley Nicole Taylor. I'm going to say Goshel, and she can correct me when she gets up here, because I probably did not go say Gazelle. I apologize. I'm sorry. What we're looking at on hers is the Worsham College of Mortuary Science. The college conferred a degree of a diploma. There's a letter dated March the 20th from the program director that explains that. I have spoken directly with the program director. I admonished the college to change it to an associate's degree, but they won't. They say that unless they take certain courses on their campus, they will not issue an associate's degree. It's going to be a diploma. It's accredited by the American Board of Funeral Service Education, and she has been licensed for 2 years. How long have you been licensed in California? Since 2011?
That's correct. Licensed in California for 2 years, and I was licensed before that in Arizona as an embalmer for 6 years and funeral director and embalmer for 5 years. They have a 2-year funeral directing apprenticeship there.
On consultation with the Assistant General Counsel, I'd advise you to pay no attention whatsoever to question number 2. That's immaterial. The reason she's before you today is strictly on the diploma issue. And also, in case you don't remember, we had one from the same college 3 or 4 months ago, 4 or 5 months ago, same situation.
Been continuously employed for the last 5 years or longer.
Yes, that's correct.
Make a motion, we approve.
Second.
Currently employed in Tennessee.
Yes, I am. I'm working as an assistant with a funeral home.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle, to approve application of Ashley Nicole Taylor Gossel for funeral director and embalmer by reciprocity. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Congratulations. You'll see Ms. Lisa, and she'll give you the information you need. Next to appear before the board, the consideration before the board is reinstatement of suspended license. I'd ask you to look on your iPads, pull that information up.
President.
Yes, sir.
Mr. Baker, in this consent order that was agreed to, the consent order said that in the event the respondent wishes to renew his funeral director and embalmer's license, the respondent must appear before the board in order to renew the license following the suspension. The intent of that was probably to reinstate. However, his embalmer's license is soon up for renewal, so either way, it's applicable that he come before the board today. And this was the first meeting subsequent to his 1-year period of time that since the signing of the consent order.
Baker here today. Baker, if you would like to approach the chair microphone over here in case there are questions that you might address. Will remind us the exact status of his license as of today, please.
His license as of today is suspended based upon this consent order, which you can see what the conclusions of law were and what the violations were for. I would also inform the board that there was a prior consent order agreed to back in 2004, Mr. Baker, along the same lines as to what this was. Not identical, but similar. Baker is working now, presently working in an establishment, but is not. We have no evidence that he has practiced funeral directing and embalming during the time of his suspension.
I've been practicing heavy.
Paid the $1,000 civil penalty.
Sir.
Original recipient of the $2,338, did they receive their funds?
Sir.
Related to these individuals?
No. Sir.
They go back to work
Yes, sir.
and do it right.
Yes, sir.
Motion to approve.
Learn your lesson. No more power of attorney uses for fraudulent means. No more insurance. Second, Mr. Hinkle.
Council, by moving in the affirmative, what action are we actually taking here?
Just allowing for his license to be reinstated at that point and removed
His
from
license, have
it's suspended currently.
they expired during the suspension, or are they still active?
They're current. The Embalmers license is coming up for renewal in 6 weeks or something, 4 weeks, something like that. 4 to 6 weeks, short period of time. And he'll be subject to whatever continuing education that would normally be required. And he may have already done that. I don't know. I've not looked. I don't know if he, like 3 hours. Okay. That's not due until the expiration of the license. It's not due until then.
Will we be lifting the suspension or just allowing the suspension to expire? Was the suspension indefinite or for 1 year period?
1 year. Just for 1 year.
Technically, the suspension has already expired if you look at it by the number of days. However, the consent order, part of the requirement was for him to appear before the board. So this is the first board meeting subsequent to the expiration of the suspension. So, as the counselor said, this was part of what was necessary in order to complete the requirements of the consent order, or the agreed order.
Right, that was part of the agreement that he signed.
Order was on March the 28th, 2012.
That's correct.
You have an insurance license?
Not yet.
Give explanation for making this change? Why did you change the beneficiary?
It's a long story, but I can go into it if you like.
I need a short version.
I left one firm and went to another firm, and one of the owner's son just came after me in general and did some things.
I didn't understand what you said. Did what? The son did what?
Just they cured some things up on me, and he kind of set me up. But his mother, while she was still living, understood everything that was happening, and she wrote it off and let it go. And then once she passed, he brought it back to surface.
Were there any civil penalties incurred against you during this process?
Sir?
Sir?
No, sir.
So the only action that was actually taken against you was action taken by this board? I have a motion on the floor by Mr. Hinkle, seconded by Mr. Neal, to allow Mr. George M. Baker Jr. to proceed with the reinstatement of his license, dual license, both as a funeral director and embalmer. Is there any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries. Congratulations, Mr. Baker.
Thank you.
Get a letter to you, Mr. Baker, but unless council advises differently, as far as I'm concerned, your license is reinstated and you're ready to go back to practice in funeral director and embalmer. But we'll get an official letter to you, hopefully later today or tomorrow, to confirm that.
Prior to adjourning, Mr. Gribble brought us up about our luncheon on May the 14th. Is there any questions about that? He also brought us up to date on the discussion with alkaline hydrolysis. Mr. Gribble, at this point, is there any particular entity that would take the lead in this further discussion, or is that just whoever comes to the table first?
We've been in discussion, subsequent to your board meeting, we've been in discussions with both Sean Tays and Ty O'Grady. I would assume that they probably will initiate those discussions. However, it appears outlined that Rawls's is something that's coming. There's a bill that's introduced up there, and it would be good to work together with all parties, whoever needs to initiate the beginning of it. It would be good for the Tennessee State Funeral Director and Mortician Association, the Tennessee Funeral Directors Association, this board, the Department of Health, Vital Records people, Department of Environment and Conservation, to get together and work this out and determine what is the best way to regulate it. And it'd be much easier done by an amendment to that bill than it would to have to start the process anew at some 2 or 3 years later down the road. And at least then Tennessee would be a state that would be prepared for it. We've had 2 inquiries. One was about 2 years ago by a Middle Tennessee funeral director. He decided not to pursue it. And then those people who came before you last month, they plan to pursue it at some future date. So, Mr. President, you may want to talk with representatives from the associations, and probably what I was kindly told was it might be best to wait until August or September, maybe September after the summer months, but 2 or 3 months ahead of the next legislative session beginning, which will begin in January of 2014. Back in session, it would be good to have a plan in place to present to those sponsors to see if they would amend their bill and go forward. It appears that the removal bill most likely is going to pass. Mr. McDonough and I have talked about that. That requires some rulemaking by this board. And if it passes, it's set to be effective July the 1st, 2013. It asked about maybe the effective date of that being January the 1st, 2014, but that did not come to pass. In its form now that it has already passed the Senate, I believe, and is in the House for consideration. The effective date's July 1, 2013.
If it passes, then yes.
Obviously, we need to wait for it to pass, but then get to work on it. Would we do that in form of a work session?
Probably initially. And we've even talked about he may have to look to see what's available as far as emergency rules, because this board may not have time once it's passed and before it's implemented, may not have time to make all the rules that you want to make through the normal process. But and also we'll need to get work with our computer people to. I mean, that's another profession that we'd be regulating and using. So we've got some computer work that we'll have to do in order to get it set up and everything like that. But I don't think that'd be a problem. I think our rules would be the biggest concern.
Legislation passes on this, then it comes back to the board to establish the rules.
That's correct.
Unless
does do
there's some sort of amendment or it's in the initial legislation that it's approved that has some stipulations to start with. That would automatically already be law, would it not? For instance, if there was something like liability issue that was tacked on to the approval, then place, would it not?
I think it would all be in place on July 1st. I think that, if I remember correctly, that is the date that's set to go into effect. So that would include everything.
And there was an amendment that was added on the Senate floor from Senator Ford that has to do with liability coverage. I can't remember if it specified the amount. I think it said that it'd be set by rule by the board, if I could recall correctly. But the only thing we do is wait till it passes both the House and the Senate and see what the final version is, and then come back to you and give you whatever information we have at that point.
We know if any other states have this, or where we could look at their laws as kind of some guidelines to go by.
This bill, if it passes in its current form, is more or less a restoration bill. It's not it's not set up and designed exactly like the Board of Funeral Directors and Embalmers is.
Regulated, are they?
The removal
Will there be
service.
regulation, not under the umbrella of this board, is
The bill in its current form would provide it be under the Board of Funeral Directors and Embalmers, and it'd be more or less they're going to register with the board. Those
they're
people.
not licensed in any way?
Technically, it's not a license, but most people
Think
don't
that's
make
coming?
they don't make a
That's com-
distinction between a registration and a license. Restoration.
But there will be a fee.
And that fee's to be set by the board. That's one thing that's to be set by the board, and I think the other thing to be set by the board is the amount of liability coverage and proof of that. Application.
So in the a firm that would engage the services of one of these removal services would need to have a copy of their registration with this board on hand, just as we have to have the registration of a crematory, that's an outside crematory that a firm uses. Is that correct?
If the board made a rule to that effect, if the board had the authority to make a rule to that effect.
Yeah, unless it's in statute, or I know it's in statute as far as you're supposed to have a copy of the license and inspection report for the crematory on file there during the
Would
inspection.
it be the same?
Do you remember if
It's not
I don't
in
think
this.
there's anything
I
in
mean,
there.
it's not in the bill in its present form. It may be amended again to include some other things, but as of the last time we saw it, that part was not in there.
The bill as presented in the House originally simply defines removal registered with the Department of Commerce. All such registrations will be for 2 years, and then the department may promulgate and adopt such rules and regulations as are reasonably necessary to carry out this section.
That mean this board, or would that be done administratively?
Well, that bill has been amended to make it the board. If it were passed in that format, it would be the department, it would be the commissioner. But the bill has already been amended once to change it to where it'd be the Board of Funeral Directors and Embalmers that would do the rules.
In that case, we would draw up a set of rules and regulations, set the registration fee as well, or would the department, we would?
Board would set the fee. We did some study when the bill was proposed on the bill analysis, and we'll have a recommendation to make to you. I can't remember exactly what that fee was. Seemed like it was $275 is the recommendation that we're going. It's $250 or $275, and I can't remember.
That's every 2 years.
The original bill.
I think it's a 2-year, every 2 years.
Could require an insurance bond and that type
That's the
for
The
liability.
Senate version has been amended to include that. It's in the statute. That was Senator Ford's amendment, that it would include liability insurance. Now, I think if I recall correctly, it's still left up to the board to determine the amount of the liability insurance. An amount set by the board.
So with that being said, if the House and the Senate pass the removal service bill, we will be or if nothing more to adapt just some emergency measures while
That's correct.
put in place. Any other business to come before this board members? Director, Mr. Counsel? Hearing none, the chair will entertain a motion to adjourn.
Motion to adjourn.
Mr.
Second.
Hale, second, Mr. Hinkle. All in favor, say aye.
Aye.
Motion carries.